Morning.
Good morning.
Good morning, everyone.
Good morning.
Good morning.
Good morning, everyone.
Morning.
Morning.
Oh boy,
Good
sharp.
morning.
Good morning. So, B. All right. Today we look at the legislation, and then I also will combine that with a review for the supplemental exam that you will be taking in a few hours. How that sounds?
Sounds wonderful.
Okay. So make sure you have your notepad handy. Listen to the hints. That will help you. As I go through, I'm going to tell you different things that you should be mindful of. That will be on this. Okay, hold
All
on.
right.
me get my manual from the beginning, from chapter 1. Give me 1 second while I pull it together. I'm ready to go. Everybody has their full manual in front of them, right?
Ma'am.
All right. Let's see. What does that do? All right. So chapter or unit 1 was on the Bahamian legal system. Do we have any questions there? We spoke about the definition of a legal system, the different types of law, the judicature of the Bahamas, and how a bill becomes an act. Any questions?
No.
Now, the last section, what I just mentioned, is on the supplemental exam, so you must know it.
What is that? How the bill becomes an act?
I'm not reading it again. You heard me.
Okay.
All right. No questions there,
Mm-mm.
because that is a process.
Yes.
Okay. So once you know the process, you'll be able to answer that question, even though it's not worth a lot of points. Sometimes you know, many points as you could find.
True.
Okay. Module 2 speaks about the tribunal itself. Talked about it historically. It gives you a little bit about the powers of the tribunal. And so if you read your book on Emmanuel Osadabe, you'd know that the establishment of the tribunal was really important to the Bahamas in terms of employment law. So the history, again, is another area that you should know. And because most matters go to tribunal before it goes to the Supreme Court or to the Court of Appeal, you should know the powers of the tribunal. So in essence, there is about 10, so you should know at least 5. And before, yeah, of course, you can't go back to module 1. Of course, you know, you can't talk about the tribunal or talk about how a bill becomes an act without knowing the judicature of the Bahamas. And you have it laid out in module 1 in word form and also in diagram. So you should be able to explain what each court is about in summary. Those right there are your bonus questions. One is missing. Let me see if I could include that one. One more bonus question I have added in there. Module 3 speaks about the employee contract. And when you would have gone over that chapter, the first thing you would have learned was that the employment contract is based on contract law. And the first step in any contract is there must be an offer and an acceptance. So one of the bonus questions is asking you to explain that. Those two elements of a contract, but relative to employment. So the bonus points total 15. Five questions. Three points each. No questions there?
We good?
Oh, only one person speaking. I will hear nobody afterwards saying, oh, I didn't know. Everybody good?
We're good. I'm good.
Okay, right. That sounds good. Now let's go over the act itself. Part 1. Gives you, of course, the interpretation of the different words. And then you move to section 5, which speaks to conditions of employment. A person employed after the commencement of this act shall be informed by his employer as soon as practicable of the following particulars: the name of the employer or group of employers, and where practicable, of the understanding and of the place. The name of the employee, the place of engagement, where practicable, the place of origin of the employee, and any other particulars necessary. The nature of the employment, where a person is engaged for a fixed period or appropriate circumstances, the duration of the employment and the method of calculating the duration, the rate of wages and other benefits, the method of calculation thereof, the manner and period of payment of wages and other benefits, the advances of wages and other benefits of any, and the manner of repayment, and where any work is to be performed not by the piece but by time, the number of hours of daily work and the hours of the day at which such work is to commence and to terminate. So all of that is what you would see in the employment letter. Now, section 6 says, no employer or person acting on behalf of an employer shall discriminate against an employee or applicant for employment on the basis of race, creed, sex, marital status, political opinion, age, or HIV/AIDS by refusing to offer employment to an applicant for employment or not affording the employee access to opportunities for promotion, training, or other benefits, or by dismissing or subjecting the employee to other detriments solely because of her race, creed, sex, marital status, political opinion, age, or HIV/AIDS. Paying him at a rate of pay less than the rate of pay of another employee for substantially the same kind of work or for work of equal value performed in the same establishment, the performance of which requires substantially the same skill, effort, and responsibility, and which is performed under similar working conditions, except where such payment is made pursuant to seniority, merit, earnings by quantity or quality of production, or differential based on any factor other than race, creed, sex, marital status, political opinion, age, or HIV/AIDS. Pre-screening for HIV status. Provided that this section does not affect any other law or contract term which stipulates a retirement age. Section 6 shall apply mutatis mutandis to disabled employees unless the employer can show that the job requirements relied on as grounds for hiring the disabled person at a lesser rate of pay are reasonable, or the disabled person cannot be accommodated without undue hardships. So now let me refer to your supplemental exam. There is a question which speaks about recruitment. And it asks you to explain job specification and manpower planning. Now, based upon that section that I just read to you, section 6, The second part of that question speaks to you having to have a discussion on what an organization should do to avoid discrimination in its recruitment and selection process. And module 5 in your manual speaks about recruitment, selection, and performance. Any questions there?
What's that point? What's that question worth?
20 points.
Okay,
10 and 10. It has 2 parts. Okay. My internet was acting up this morning, so I have 2 cases. I need you to look up now to make sure that you have it. This is still not up yet. I want you to look up the case called, it's a Court of Appeal case. So put in Court of Appeal, put a plus sign. And the name of the case is Island Hotel Company Limited. Island Hotel Company Limited. And Cheryl Carey Brown. The next case,
Sorry, Ms. Archer, that's Cheryl with an S or a C?
Cheryl, Carey hyphenated Brown. And the next case is an industrial tribunal case. Bruno Roll, and Westech, Westech Security. And Christopher Washington Adderley. Let me know if you find it, because otherwise I'll send it to you later when the internet comes up.
Ms. Archer, the one for Carey Brown, is that the judgments or you want the tribunal one?
One for Carey Brown is the Court of Appeal.
Oh, okay.
Court of Appeal.
All right.
That one that's listed as case number 13 of 2017?
Yes.
Okay.
Everybody found it? I see two found it.
Found it.
Okay.
I found it.
All right.
Copy the links into the chat, just in case anyone couldn't locate them.
Okay, so I've given you the bonus, 5 questions, 3 points each. And I've given you one of the questions that you have to answer that's worth 20 points. There's a part A and a part B, module 5. So now let's go back to the Employment Act and the standard hours of work. Section 8. It says, except as otherwise provided by or under this act, no employer shall cause or permit any employee to work in excess of 8 hours in any day or 40 hours in any week without the payment of overtime pay in respect of any such excess in accordance with Section 10. And Section 10 speaks to overtime pay. Did you all discuss overtime pay?
Yes.
All right. Provided that the standard hours of work shall be 44 hours in any week for the period February 2002 to February 1st, 2003, and 40 hours in any week after February 1st, 2003. So notwithstanding anything in subsection 1, where by reason of nature of any employment, the hours of any employee for the purposes of such employment are required to be irregular, the standard hours of work in a day or week of any such employee may be calculated as an average over a period not exceeding 4 weeks. Notwithstanding subsection 1, in any industrial, construction, manufacturing, or transshipment enterprise, or in any essential service within the meaning of section 72(2) of the Industrial Relations Act or law enforcement services, the hours of employment of an employee for the purposes of such employment may exceed the standard hours of work in a day up to a maximum of 12 hours, and the minister may by order include other enterprises or services within this subsection as he deems fit. The section shall not apply to a person who holds a supervisory or managerial position. In every 7-day period, an employer shall allow each employee at least 48 hours of rest, with not less than 24 of such hours being consecutive. And a period of 24 hours rest is in this act referred to as a day off. Where an employee is required or permitted to work in excess of the standard hours of work, he shall be paid in respect of such work at a rate of wages not less than, in the case of overtime performed on a public holiday or day off, twice his regular rate of wages. In any case, 1.5 times his regular rate of wages, provided that an employee in a tipped category in the tourism and hospitality industry shall be paid at his regular rate of pay other than in respect of his second day off in any week. And any wages paid or be paid or to be paid as required by this section are in this act referred to as overtime pay. So I don't have any question on overtime. I hope she would have covered that. But I want us to turn to the case of Bruno Roll and West Tech Security. So even though this case focused on whether or not he was laid off or abandoned, the question in the exam goes around the industrial rules, the process. So you need to read the case carefully because it speaks to what the industrial tribunal can do and cannot do and what it accepts. So Bruno Roll had made 2 claims against Christopher Washington Adley, trading as West Tech. Firstly, Mr. Roll contends that West Tech, for whom he had worked as a security guard from June 11, 2012, laid him off or put him on standby and never called him back to work from the 26th of December, 2016. Mr. Roll contended in the proceedings that he received no notice or pay in relation to the cessation of his employment from West Tech. Secondly, Mr. Roll contends that he worked overtime hours for West Tech, but was not paid overtime pay as specified by the Employment Act. However, while the dispute referred by the minister referred to both of Mr. Roll's claims, in his originating application filed on the 13th of November 2017, he failed to include the claim for overtime pay. The respondents as West Tech raised the issue during the trial that the overtime claim was not set out in the originating application. Remember now, this question is on the process. The first question for the tribunal is whether it can consider a claim not set forth in the originating application. Based on authority, the answer is no. Island Hotel Company Limited versus Rudolph Pinder. The minister referred to the industrial tribunal for consideration a dispute framed wrongful dismissal and a breach of employment contract, contrary to section 34 and 35 of the Employment Act. In the corresponding originating application filed with the tribunal, Rudolph Pinder's legal counsel pleaded his dispute as unfair dismissal and breach of employment contract pursuant to sections 34 and 35 of the Employment Act. At first instance, the tribunal considered both causes of wrongful and unfair dismissal and gave a decision that the applicant was not unfairly dismissed, but rather was wrongfully dismissed. The respondent appealed. Upon his review of the tribunal's decision, on the 3rd of December 2018, the Court of Appeal allowed the appeal on the basis the tribunal erred in that it exceeded its remit in considering the question of wrongful dismissal, where unfair dismissal was the relief sought in the originating application. For clarity, an applicant deliberately or erroneously may omit from his originating application a dispute referred by the minister. Whichever is the case, the tribunal may consider a dispute only if it has been included in 2 documents. 1, the referral. Firstly, the dispute must form a part of the referral by the minister, pursuant to section 72 and 73 of the Industrial Relations Act. Where the minister's attempts to resolve reported disputes fail, the minister is directed by statute forthwith to refer those matters to the tribunal. Typically, the report of a trade dispute, which accompanies the minister's certificate of referral to the industrial tribunal, is the document in which the potential applicant must set out his description of the dispute, for it is usually referred as described in that form. 2, the originating application. Secondly, the applicant must settle the dispute in the originating application filed with the tribunal. That is required by Rule 3 of the Industrial Relations Rules. An applicant's failure to settle the dispute in the originating application, regardless of whether it is due to a clerical error or misconception of the law, cannot be remedied by an amendment. As observed in Island Hotel Company versus John Fox, number 54 of 2017, there is no provision in the Industrial Relations Act or the Industrial Relations Tribunal rules which enables an applicant to amend his originating application to correct his mistake. Until such an amending power is legislatively created, great care in drafting, or in the case of an error, some artful use of the 2010 rules will have to be employed by an applicant or his legal representatives to bring his dispute properly before the tribunal for full consideration. So the question is around the same issue with Mr. Bruno Roll and his former employer, but looking again, like I said, at the process. And it asks you 1, 2, 3, 4 questions. And it's worth 10 points. And it all has to do with the process. So don't spend a lot of time. You could, after the exam, you could read the case to see the conclusion, but the actual question is on the process. Did you read the industrial relation rules? If not, you can go to the website, Laws of the Bahamas, and then just look at the rules that they're referring to in this section. You know, you have to read section 72 and 73 of the act itself, and then rule 3. The answers to this question is not long. These 4 questions, they're not long. It's not a one-word answer, but it's really only 2 sentences for each one.
You said to read section 72 and 73 and
Of
Rule?
the Industrial Relations Act and Rule 3
Ah.
of Industrial Relation Rules. That question is worth 10 points. Okay. Now, the next question is also worth 10 points. It takes you back to, let me get to find the chapter. Yeah, someone read that. Oh, my finger was just on it. Just hold on 1 second. Right here. Module 4. The employee and employer, the employer-employee relationship. And remember, I told you all in the last class that the duties of an employer are very important when it comes to employment law, when an employee wishes to sue, and also the duties of an employee. So my question in the supplemental exam is on the employer's duty to accommodate. Now, where's my act? So section 7 says, section 6 shall apply mutatis mutandis to disabled employees unless the employer can show that the job requirements relied on as grounds for hiring the disabled person at a lesser pay of rate are reasonable, or the disabled person cannot be accommodated without undue hardship. So in this case, this person was already employed in Island Hotel versus Cheryl Carey Brown. She had been employed in Atlanta since 1981. In October 2009, she was injured in a car accident, suffered nerve injury. She returned to work in October 2010 with a letter from her physician recommending that she worked morning shifts only due to the nature of the medication she was prescribed to take at night for her injuries. She was placed temporarily at another restaurant to work for a short time. Sometime later, the restaurant hours in which she served as manager was changed and was no longer open in the mornings. The only shift was a night shift. She was terminated because of her disability and inability to perform the work of a restaurant manager at night. The issue in this appeal is whether the employment came to an end by virtue of a dismissal, which was wrongful, or whether it came to an end by virtue of the doctrine of frustration. And the court allowed the appeal. It said, in our view, the analysis of the law with respect to the doctrine of frustration in relation to employment contract in the Bahamas is similar to the law as expressed in the case of Warner versus Armfield. That had substituted for the provisions of section 6 and 7 of the Employment Act for the provisions of the Equality Act of England. That is to say, in the case of a disabled person, before the doctrine of frustration can apply, in addition to the factors identified in the egg stores case, a court must consider whether the employer is in breach of his duty to accommodate. An employment agreement cannot be held to be frustrated by an employee's disability unless the employer can show that he could not accommodate the disabled employee without incurring undue hardship. In this case, the evidence does not show that at the time of the dismissal, the appellant was mindful that it had a duty to accommodate unless it would cause undue hardship. The evidence indicates that the appellant simply determined that it had no other available job for a restaurant manager other than one which required the employee to work at night. That since the employee, because of her disability, could not work at night, they regarded the contract as having been frustrated by the employee's disability and brought the contract to an end. This is apparent from the termination letter, where the appellant stated that it considered other areas of opportunity which may be suitable to her condition, and that unfortunately, there is no suitable position at this time which would be conducive to your current medical condition. The evidence does not show that the appellant considered adjusting her work schedule to allow her to work in other restaurants in the day, or considered adjusting the schedule of those managers without disability who were able to work in the night. The evidence established that the respondent could not properly discharge her duties as a manager in the day. She had done so at the clubhouse in October 2010, while the manager of that restaurant was on vacation. So you could see from this case, it demonstrates the employer's duty to accommodate. And the court also sets out that before you could even look at whether the employee frustrated the contract, the court says the employer himself had to look at whether or not he's breached his duty to accommodate. Any questions? Any questions?
Oh, just trying to keep up.
Ah,
Can you repeat that one more time, please?
which one?
Your last sentence.
It's recorded. I have no clue what I just said.
I think, just to paraphrase, you were indicating that, the Cheryl Brown case referred to the employer's duty to accommodate.
Okay, now who's saying they have to keep up?
That was Kendra. I was saying I was just following and keeping up. When
Okay,
you asked about questions.
yes, in that same case, it's page 13, paragraph 31. That's when the court looked at the question whether or not the appellant discharged its duty to accommodate. And it gave you a good rundown of the US definition of discrimination of disabled persons. It also spoke about reasonable accommodation, what it means in American law. And it also tells you that the Employment Act never gave any guidance on those two. Because even though it says reasonable accommodations and undue hardship, the law does not give a definition of what that means. The case also refers to an article in the Canadian law of University of Western Ontario on the duty to accommodate in a Canadian workplace. And based on all that, in paragraph 38, it says, as far as we are aware, this is the first time that our courts have been asked to evaluate whether an employer has discharged its obligation to provide reasonable accommodation for an employee with a disability. So this was their very first case on this. They said, unfortunately, in this case, as an appeal court, we are hampered by the fact that on the evidence, it does not appear that the appellant actually addressed its mind to its obligation to provide reasonable accommodation to an employee with a disability to the extent of undue hardship. The evidence indicates that the appellant simply determined that it had no other available job for a restaurant manager other than one which required the employee to work at night. That since the employee, because of her disability, could not work at night, they regarded the contract as having been frustrated by the employee's disability and brought the contract to an end. This is apparent from the termination letter, where the appellant stated that it, quote, considered other areas of opportunity which may be suitable to her condition, end quote, and that, quote, unfortunately, there is no suitable position at this time which would be conducive to your current medical condition, end quote. The evidence does not show that the appellant considered adjusting her work schedule to allow her to work in other restaurants in the day and or considered adjusting the schedule of those managers without disability who were able to work in the night. The evidence established that the respondent could properly discharge her duties as a manager in the day. So in paragraph 45, they say, I have no doubt that the appellant tried to accommodate the respondent and was of the view that because it did not have a vacancy with a day shift, it could not accommodate her disability. But in our judgment, the law requires more. The burden is on the appellant to show that it could not accommodate the respondent with her disability without incurring undue hardship. They must do so before they could rely on the doctrine of frustration. So as the vice president held, it is reasonable to say that the respondent could have found an alternative to dismissing the applicant. Though the respondent stated it made provisions to find alternative employment for the applicant, the question is to what standard were attempts made? There is no evidence presented by the respondent that her position as manager was in jeopardy, or they urgently needed an able-bodied manager due to demand at the restaurants. There was no evidence that showed the respondent could not wait any longer for the applicant to return to work. An enterprise such as the respondent has many departments that may have satisfied the applicant's tenure, position, and experience gained over 30 years of employment. In our view, the finding by the Vice President is reasonable on the evidence led. They have not demonstrated that it would have caused undue hardship to have accommodated the respondent with her disability. They have not done so and therefore cannot rely on that doctrine as the basis for bringing the contract to an end. And so they said the tribunal was entitled to find that respondent was wrongfully terminated. So in your supplemental exam, you're going to see a termination letter. And you have to discuss the duty to accommodate. And this case lays it out quite clearly. Any questions?
No, no, ma'am.
Okay.
Ms. Archer,
Mhm.
am I understanding that even though she was dismissed, they couldn't use the frustration clause?
Correct.
Okay, because they didn't prove how they became frustrated in finding her some other employment somewhere else in the hotel.
Remove the word frustration from there. They had a duty to accommodate.
Right, so,
They had to exercise that obligation first.
right, to find somewhere else for her in the hotel.
Yes.
Okay, but they seem to have only focused on the restaurants, the restaurant area.
Yeah, exactly. And they didn't even try to see if there was someone who was working in a day who could have shifted to work in the night,
Better to work in the night, yes.
accommodate her.
Right.
All right.
Yes, Archer, if they had gone that route, and let's say they had made an appeal or did a search to see who could switch with her to work at night and she work in the day, and there was no offer or acceptance by another employee to make that switch, would that have justified their search to
No. Then they'll have to look at the persons who work in the day, see if there was any function there where she would have been able to work. She'd worked there for a very long time.
Mhm.
So she's quite knowledgeable. So you have to go to all lengths to see if you could accommodate your employees before you terminate.
So what if they said, okay, we are going to move manager B to night shift so that we can accommodate Cheryl on a day shift, and manager B had a complaint with that? Is
But
that
then-
now another case coming up now with manager B?
Yes, but then when you look at the situation, on what grounds are they going to go to tribunal on? That you changed their shift?
Yeah, unilateral change of, I don't know.
No,
shifts, work
but then
time?
you have to look at the employment contract. I'm sure
Right.
I'm sure the contract didn't say you're working only nights.
Right, I was gonna say that too. I was gonna say, what did the contract say? Because they sure it said you would be on a shift schedule where you'd have mornings and nights. So did you come and change it now and tell me just nights to accommodate someone else like Catherine
Right.
has?
Because
That
the
opened a new can of worms.
yeah, the only issue would be if you gave that staff adequate notice. You know what I
I could
mean?
notice that you were gonna change my shifts.
Yes.
And
That
I
What
is
they
still declined,
volunteered.
and the person still declined, yeah.
then you go back to the employment contract.
Which is gonna be
Yeah, 'cause
bad for the employee. The employer, sorry, because the
Mhm.
contract stated shift, morning and night.
Right.
I guess what would be reasonable in that is you would need at least 2 other managers to agree to work more night shifts to accommodate Cheryl. And
Mhm.
therefore they could have an option of some nights, some days.
Right. Yes. But then remember now, just as the judge said, they have many restaurants. There has to be a way to accommodate her.
Yeah.
And they just didn't.
This is
exhaust it.
interesting because I didn't realize how deep the responsibilities of the employer went to accommodate, because it's not something we typically encounter, you know, it's,
Yes, but it can happen.
yeah.
Yeah. But it's a good case to sit down and read in its entirety, especially looking at the references to the American and the Canadian perspective on that duty to accommodate. Because when you would have done the very first unit in when you started this course, you realize that yes, we are part of a Commonwealth jurisdiction. And that means that the judges and the lawyers can refer to other Commonwealth case law.
Mhm.
And in this case, you see where they pulled on the US law and they pulled on the Canadian law. So it depends on how you are arguing the cases. You can pull from laws from Malaysia, laws from Hong Kong to bring your point home, especially where the laws of the Bahamas are silent.
Wow.
So it's a very good case, at least to keep in your file in HR on that duty to accommodate.
Definitely.
Yeah. So my last question on the exam is worth 10 points. And it's on the duty to pay. Now, this case for this duty to pay is an English case. And the name of the case is Cantor, Cantor, Fitzgerald, Fitzgerald, International versus Callahan, Callaghan. 1999. To All England, ER 2ALLER 41. So in this case, the Court of Appeal made it clear that in a contract of employment, the contractual arrangements for pay between employer and employee were of crucial importance. Deliberate and determined refusal by an employer to honor an agreement, thus diminishing the value to the employee of an agreed salary package, amounted to a repudiatory breach. So in this case, the employees were members of a team of brokers employed by Cantor on his Belgian government securities desk. Their contracts with Cantor made provision for payment to each of them of 4-year forgivable loans of £60,000 each, which included arrangements to exclude any prospect of tax liability being incurred by the employees. As a result of subsequent changes to tax legislation, each employee became liable to tax on the imputed benefit of the interest-free element of the loans. Cantor refused to do anything about this. In 1997, the employees handed in a joint notice of termination, intending to start work with Cantor's rivals. For the purposes of the appeal, the employees claimed that their contracts had been repudiated on the ground that Cantor had wrongfully failed or refused to comply with agreed salary arrangements. So according to Judge LJ, the question of whether non-payment of agreed wages or interference by an employer with a salary package was or was not fundamental to the continued existence of the contract of employment depended on a critical distinction between an employer's failure to pay or his delay in paying agreed remuneration on the one hand, and his deliberate refusal to do so. Although a failure or delay constituted a breach of contract that might represent no more than a temporary fault in the employer's technology, an accounting error or mistake or illness or unexpected events? If so, it would be open to the court to conclude that the breach did not go to the root of the contract. On the other hand, if the failure or delay in payment was repeated and persistent, perhaps also unexplained, then the court might be driven to conclude that the breach or breaches were indeed repudiatory. Where, however, an employer unilaterally reduced his employee's pay or diminished the value of his salary package, the entire foundation for the contract of employment was undermined. Therefore, an emphatic denial by the employer of his obligations to pay the agreed salary or a determined resolution not to comply with his contractual obligation in relation to pay and remuneration would normally be regarded as repudiatory. Judge LJ stated that it was doubtful the concept of de minimis had any relevance in this field. If the amount at stake was very small and the circumstances justifying a minimal reduction were explained to the employee, then the likelihood was that he would be prepared to accept new terms by way of mutual variation of the original contract. That sounds like the 6%, right? We were discussing last week. However, an apparently slight change imposed on a reluctant employee by economic pressure exercised by the employer should not be confused with consensual variation. And in such circumstances, an employee would be entitled to treat the contract as being discharged by the employer's breach. Here, in the context of the overall salary package, the amount at issue was not very great. However, the refusal to pay was deliberate and determined, motivated by a desire to pressurize the employees into harder work. The decision wholly undermined the contract of employment and constituted a repudiatory breach. Were you able to find a case online, Cantor versus Callahan?
I'm still looking. They have so many search.
Yeah. On some of them, you have to sign up for.
Yeah.
So in the supplemental exam, the facts I read to you are in the exam.
Okay.
What you have to discuss is the employer's duty to pay, or his delay in paying agreed remuneration versus his deliberate refusal. So remember what I said. An employer unilaterally reduced his employee's pay or diminish the value of his salary package, the entire foundation for a contract of employment was undermined. An emphatic denial by the employer of his obligation to pay the agreed salary or a determined resolution not to comply with his contractual obligations in relation to pay and remuneration would normally be regarded as repudiatory. So the question you have to answer is whether when an employee's duty to pay or his delay in paying an agreed remuneration versus his deliberate refusal to do so, would that amount to a repudiatory breach? I'll see if I could find one. But the facts of Cantor is actually in the exam. Remember what the judge says. He says, if the amount at stake was very small and the circumstances justifying a minimal reduction were explained to the employee, then the likelihood was that he would be prepared to accept new terms by way of a mutual variation of the original contract. However, an apparently slight change imposed on a reluctant employee by economic pressure exercised by the employer should not be confused with consensual variation. And in such circumstances, an employee would be entitled to treat the contract as being discharged by the employer's breach. And so he said the refusal to pay was deliberate and determined, and is motivated by a desire to pressurize the employees into harder work. And so it amounted to a repudiatory breach. And that's your supplemental exam. Any questions?
Just a request, if anybody can share their notes with me. I wasn't able to take notes, I was on the road. Could you
Oh.
please? Thank you.
Did anyone write it down? You have it clear that you can share it with Tehran?
Mine's not the clearest, but I'll send it to him.
Okay. So I don't want to take up too much of your time. I know you have to study and I know you have to read. And I expect good things because I have to write the final exam for next class.
The exam is next class or the class after?
Class after.
Okay.
Yeah. No, I'm saying
Almost
when
caused me to panic.
no, when we come next week, I'm going to tell you what's on the exam.
Okay.
Yeah. And that would include case law also.
Oy.
I'll tell you which cases, just like how I'm doing now. I'll tell you the cases that you need to read in order to prepare you for the exam.
Great, great, great.
So try to be on time because I know normally when I finish giving the review as to what's going to be on the exam, I don't review the whole 6 chapters. I'm telling you what's coming on the exam. So you are prepared. You don't go all over the place. But then students begin to panic because they haven't read the cases before. So this will be the first time that they're reading it, and of course, then they begin to panic. So I don't want nobody panicking.
Okay.
We appreciate that.
Okay. All right. So I'm gonna let y'all go now. I hope when I get these papers by tomorrow, I see good things.
Thank you.
Okay.
Thank you so
Yes,
much,
ma'am.
Ms. Archer.
Ms.
Ms. Archer, I-
Archer,
All right. Yes.
sorry, for those who just doing the exam for practice, do we still have to submit it to you or how does that work?
It's up to you.
Okay,
Yeah.
All right.
If you want to, you can send it. If you don't want to, then you keep it.
okay. I have another question. Were you able to provide the point allotment for the capstone assignment?
Oh, shoot, I forgot. I'll email it to you all.
Okay,
But I
thank
forgot.
you.
Okay.
Ms.
One more
Archer.
question.
I didn't put it on my little thing. Okay. Next thing up.
One more question. For those who are not doing it for practice, and those who already took the first one and want to take this other one, would you go with higher grade?
Of course.
All right.
Of course.
Good.
So,
Thank
Ms.
you.
Archer, we have a link for this supplemental exam. Is it the same as the one for the class?
I am not sure. How, yeah, I'm not sure how Miss Dean is doing it. But I'll
Okay, so
send it.
we'll get something before 1 o'clock then.
Yes, I'm gonna do it now.
Okay.
Okay?
Miss Archer, good morning.
Yes.
I would have sent you an
Morning.
email. Oh, I'll send you a note right now before you log off.
Okay, all right.
Also, Ms. Archer, I requested a change of email address. I put it in the chat, but I can shoot you an email as well. I
Okay,
sent it to Mr. Miguel.
okay, all right, send it to me. Yes, I can share
Okay.
it with Christine.
Okay, thank you.
Okay, all right. Okay, so let me call Miss Dean to see if they're ready for the supplemental and how they're doing it. Okay,
Okay, thank you.
all right. So have a good week and be prepared for next week. I don't want to hear no screamings. All right,
Yes,
All
ma'am.
right.
all right.
Okay.
So good
Okay.
luck.
Good
Good
luck,
luck.
everybody.
Okay.
Okay.
Have a good day.
Yeah.